Welcome to Business Line's State of the Economy podcast, where you'll find insight, analysis, and the story behind the numbers.
Hey there, welcome to the BL State of the Economy podcast. I am Srivaths from Business Line, and today we have a very interesting topic at hand, which is CCI's draft regulations on Leniency Plus program. We all understand that cartels have a pernicious effect and need to be squarely tackled for several reasons. More so, as cartels, often described as secret agreements among competitors to manipulate markets, undermine the very essence of competition. They result in market distortion by artificially manipulating prices and reduce competition. They also result in economic inefficiencies and do consumer harm besides stifling innovation. So, tackling cartels through effective antitrust and competition policy is therefore essential to promote fair competition, protect consumers, and foster economic growth. In response to the cartel menace, competition authorities worldwide have devised leniency programs as a crucial tool to combat cartel activity and restore fairness to markets. India too has been from time to time tweaking its regulatory norms to address the cartel's menace. The latest effort from the Competition Commission of India on this front is its move to issue a draft of the revised lesser penalty regulations that provides for introduction of the Leniency Plus program, which is basically a new cartel detecting tool. The draft regulations sheds light on how the competition watchdog intends to operationalize it. So, what exactly is Leniency Plus? And will its introduction lead to faster market corrections and increased reporting of more cartels by the cartelists? To help us navigate this critical question and do a deep dive into the utility of the draft regulations in addressing the cartels problem, we today have an eminent competition law expert in Sharma, who heads the competition law and policy practice in the law firm Vaish Associates Advocates since the year 2009. Sharma, who has a wealth of experience spanning over 38 years, holds a postgraduate diploma in economics of competition law from King's College London. He has worked in the Competition Commission of India as an additional registrar during 2006 to 2008 and was responsible for drafting the implementing regulations under the Competition Act 2002. He is a prolific writer on competition issues and has few international publications in noted journals to his credit. He is also the editor of the firm's bi-monthly newsletter on Competition News Bulletin, now in the 13th year of publication. Welcome to the BL State of the Economy podcast, Mr. Sharma. As a competition law expert, my listeners would like to know what exactly is a Leniency Plus program that CCI is looking to introduce.
Thanks, Srivaths, for having me in this podcast. Now, Leniency Plus program is actually a kind of a self-reporting mechanism for those who had been in a cartel, and it is in the form of an additional incentive which is being proposed to be given to the members of a cartel who are already involved in one cartel, but during investigation they find that there is another cartel which is also in operation, so they will disclose that cartel and get the benefit of an additional incentive in the up to 30%. So it is actually an additional sweetening of the leniency scheme which is already existing.
So, Mr. Sharma, that takes me this question, right? One would like to understand how is Leniency Plus different from the existing leniency scheme?
See, there is not much difference except which I'll just tell you. I told you the sum and substance is that the additional incentive provided for disclosure in another cartel. Second difference is there's a right of withdrawal provided, which was not there earlier. So right of withdrawal is a new facility that has been extended to the leniency applicants. And all those conditions which were existing for the leniency scheme will remain. That is, they should make a true, full, and vital disclosure, which should be sufficient to the commission to form a prima facie opinion about the existence of another cartel. And of course, they should cooperate genuinely, fully, etc., and expeditiously throughout the investigation. So these conditions which were prevailing for the leniency scheme, existing leniency scheme in India, they continue to prevail in the case of leniency plus. But the advantage is that A, they have a right of withdrawal, and secondly, there is another incentive being provided for. I'll give you an example just to illustrate this. So suppose, for example, I have already disclosed about a cartel, and I'm a leniency applicant in a cartel under which the investigation is going on. Now, during the course of investigation, I discover that there's another cartel which is in operation in the same industry or in the related industry, and there are so much of evidence already existing in the commission, or they find that it is so incriminating already that it is better if they go and disclose about the other cartels to get the advantage of first mover, to get the advantage of waiver of penalty. So then this facility allows such an applicant, such a cartel member, to get the additional benefit. For example, suppose in the first cartel, I am an applicant who is put as a market number 2. So I will be entitled only to 50% of reduction. So in this case, if I disclose the second cartel, I will get an additional incentive of 30%. Apart from the benefit which I'll get for the second cartel, I may be the first, perhaps, to disclose about the second cartel. So then I'll get 100% for that case. But for the first cartel, I'll also get additional incentive of 30%. That means I'll get in favor of 80% in the first cartel and 100% in the second cartel, provided I'm the first. So this is the additional advantage, which certainly, it's slightly making the deal slightly more attractive, in my view. The two basic differences, right of withdrawal and the additional incentive. These are the two differences.
So the right of withdrawal is with the leniency applicant, I suppose.
Yes, of course. What happens is that as we go on, I'll tell you what are the pitfalls why this leniency scheme has not been so successful so far. Those I will discuss later. But answering to your question, the right of withdrawal is a right which was not existing earlier. The once you have given a leniency, you are bound by it. I mean, you can't withdraw from it, whatever be the consequences you might face later on. But you had no right to give a second thought whether I should go ahead with it or not, because the leniency disclosure include two things. One is the identity, and the second is the information which you disclose. So here what has happened is that the identity will be kept secret, but the information will be used by the commission even if you withdraw. And then, except your admission, all other evidences will be used by the commission. That is obvious. That goes without saying that it has to be done. Because in any case, you are under investigation before the commission. So the right of withdrawal will at least protect the identity of the applicant, but will not protect the information which he or she would have given.
Now, the big question in everybody's mind is, will introduction of leniency plus lead to reporting of more cartels by cartelists?
That is the intention behind introducing this program, because this suggestion was given by stakeholders, including me, before the Competition Law Review Committee in 2018, headed by the then Secretary of the Ministry of Corporate Affairs. And the idea was that we should incentivize this program more, because you see, cartels are hard to detect. The direct evidences are not easily available. It's very difficult to prove a cartel. Actually, cartels are formed in secrecy. Nobody will, go to the rooftop to disclose that what we are doing, because in their heart of their heart, they know what they're doing is wrong. The corporates know it. Of course, in India, we got knife cartel. The people don't even know that this is illegal. So India, we got abundance of cartels is there, I would say. With my experience as somebody who has filed perhaps the maximum number of leniencies in India, we know we have more knife cartels than actual hardcore cartels in India. Medium-sized companies, the MSMEs, they don't know that what they're doing is wrong. They go ahead with the kind of groups they make, WhatsApp, etc. With this program coming through and the right of withdrawal also being provided, I'm quite sure that it will increase the number of such cartels being reported. But with the caveat which I'll make now, that however the empirical study conducted so far does not disclose that the people come to the commission for the fear of only waiver. That is not true, actually. There are other factors which may be discussed later.
The moot point here, sir, is that why is it that the existing leniency scheme is not, or program is not working well? And what makes you think that the leniency plus will work well?
See, as I said, the leniency plus and leniency are not much different. The leniency plus has an additional advantage of only getting 30% more. I repeat that it is the depends on the marker status which you get. So you will get an additional advantage in your marker status in the first cartel, also the waiver of penalty in the second cartel, which you disclose. See, what happens is that naturally the cartels will be there in the same industry. There cannot be a case that a cement cartel member will disclose about a sugar cartel. That is not possible. So in the cement industry, suppose there is one cartel being investigated for a certain period. The cartel members find that there is another period for which the cartel also existed. It will disclose about that cartel and get a benefit. So to that extent, certainly it will benefit. But the pitfall is that leniency as such was not successful. The reasons for the being not successful was there are three reasons which I can straight away come to, and that my comment you can take. Number one is that this is too little, too late. The waiver of penalties, of course, 100% is an attractive benefit, but this actual what happens in the practice, the commission does not disclose the marker status till the end of the investigation, and even till the order comes. That is most unfortunate part. In practice, the competition commission does not disclose what marker they have given. That is number one. So people are left to just imagine. The lawyers will give them that you are number one. I mean, the lawyers also don't know. So that is one big question which the commission has to answer. Second factor, which is very important, is the fear of getting blacklisted. So most of the cartels most of the leniency which have been filed relate to public procurement cases. You are doing bid rigging, you're a supplier to a public procurement. And with my experience, mostly in the case of railways, the fear of getting blacklisted for say 4 years or 5 years if you are found to be involved in a cartel, and if you admit it. So actually, leniency is like a prisoner's dilemma. You have to admit before you get any benefit. So once you admit, you can't get out of it, and that means you are a sitting duck for the department concerned to blacklist you. That is number two. Number three is the right of private damages. So, like we had in the West, we also have a provision of 53N compensation. So the cartel members fear that if we admit, we will get compensation suits will be filed against us by the third parties or the victims. There are live cases. In this case, there was a very important case in which I was involved, of Mahajenko cartel, the cartel of coal licensing agents, and the compensation already has been filed. That is the third point. There is no exemption from the right of private damages. And of course, the fourth is the loss of reputation that remains, and of course, the fear of getting reprisals from your other colleagues in the industry. That how will they deal with you? Maybe they also blacklist you. They also boycott you. That also remains. That is very real. Let me tell you. Reputation, of course, is there, but loss of face in the industry itself. With my experience, I can tell you the people are really fearful. They go to the last mile to protect their identity. So they are very careful that identity should not be disclosed. So these 3 or 4 are some of the reasons why the leniency scheme has not been successful so far. And these problems have not been removed even in the leniency plus.
Okay, so you feel that those problems persist?
They do persist. And I have got certain suggestions to make if you allow me to.
Sure, sir. Go ahead.
Thank you. So see, what happens is, suppose I'm an employee and I'm working in a company which I know is involved in a cartel. I'm suppose the head of sales, somebody. I learned about this benefit of leniency scheme. Now it allows individuals also to come forward. Luckily, it allowed earlier also. So individual, if it gets the benefit, who will get the benefit? The benefit will be given to the company. Now it is up to the company to decide to seek benefit for the individual or not. Because the company, in all probability, is going to fire that person. And not only fire, he will be the target. Right? So it is left to the company, which is the company is an applicant. An individual per se is not the applicant, because individual has no identity. Individual is working for the company, so company will be the applicant for leniency, not the individual as such. Right? So company decides whether the individual get benefit. That is number one. Number two, so this should be separated. The liability of the individual and the liability of the company should be actually clarified, which is not being done. And secondly, you see, why not include the whistleblowers? Here you are incentivizing only members of a cartel to disclose about another cartel. What about a case where I'm in the industry, I know there's a cartel going on in some other mandi or in some other market, but because I'm not a part of that cartel, there's no point in my going to the CCI and disclosing, because I don't get any benefit apart from the fear of the reprisal, which I just mentioned to you. So that incentive has been totally is not there. Actually, more or less, the cartels are prevalent all over. So the benefit should come, and we will allow whistleblower to come and protect their identity and not only protect their identity, you should actually reward them. So the whistleblower program is the biggest, the absence of a whistleblower program in India, including the Whistleblower Act, which has been hanging, for the last 30 years in the parliament. The parliament has not even passed a Whistleblower Protection Act. We have got a number of good Samaritans in Indian corporates. We know, I personally know of very senior people who actually would want to disclose, but they are fearing that we may got even the corporates may do anything to us. The corporate espionage is there; it exists. The point is that the whistleblower protection program is the biggest, would be the biggest boost for the CCI if it really is serious, and it exists in other parts of the world. I'll give you some example. In Europe, in the Slovak anti-monopoly authority has introduced a cartel enforcement reward scheme. They give reward up to 1 lakh euros. Hungary, there is a reward of up to 1% of the total fine levied on the infringement decision, with a cap of 1,50,000 euros. So incentives, unless you provide incentive to employees of companies, and including companies, of course, to come forward to disclose cartels in which they may not be part of. You see, why don't you increase the good industry practices? So that is what, in my opinion, lacking in the entire leniency program.
Sharma, your point is leniency program or leniency plus should be opened up to whistleblowers.
Yes, it should include whistleblower, and you should give the same benefit of confidentiality, protecting the confidentiality of identity of the person which you are doing in the leniency.
Is leniency program open to whistleblowers now?
No, of course not. It is open only to a member of a cartel. If you are a member of an existing cartel, then only you get benefit, and then only your identity will be protected.
So how does this play out in other jurisdictions? Are whistleblowers encouraged?
Yes, in advanced jurisdictions like European Union, the national competition authorities, some of the national competition authorities have introduced the whistleblower program. I gave you examples. In UK, it exists, for example. The OFT, Office of Fair Trading, and the CMA, now of course CMA, Competition Market Authority, has recently introduced the reward they've increased the reward from £1 lakh to £250,000, and after that increase, they are getting a lot of leniency applications. They have excellent record the Britishers have done. Why don't we follow that? The earlier reward program was only up to 1 lakh British pounds. Now they've increased to 2,50,000, 2.5 times. And there is a rush to the CMA. And in India, we have maximum number of cartels, I tell you. In fact, according to me, this leniency plus is too little, too late. It's not very sufficient. It is not sufficient from me as somebody who has filed many leniencies. We know the companies come to us and say that, Mr. Sharma, how do we get benefit? Fine, you'll get us even 100%, but what about the consequences? Can you prevent us from being sued by our customers? I have no answer. Right of private damage remains.
Yeah, so that right of private damage continues to be a gray area, or is it well defined legally?
It is well defined, sir. It is very well defined. 53N is there in the law. Compensation can be claimed. It's only a matter of time that it gets let 1 or 2 compensation cases be decided. They're all pending as of now, the appellate tribunals, because the appeals are in the Supreme Court. So when the Supreme Court decide those appeals and the compensation applications which are pending are adjourned signed in the NCLAT, the appellate tribunal, and when one of the first of the compensation application gets rewarded, you'll see a flood. Everybody will rush. I'll give you the example of DLF case. Of course, it's not a case of leniency, it's a different case, but in DLF case, the Belair Association is waiting to file compensation. They have already filed. But because the appeal is pending in Supreme Court, they are helpless. In India, you see, the problem is the cartel members know the legal process we have is so slow that they can play out with it with the best of the lawyers. They help them also. I mean, that's the system, how it works. So it's not, so delay is the biggest thing, delay in adjudication, delay in deciding the compensation, delay in deciding the carteling.
So one more thing, now there is a perception that this both leniency and leniency plus are essentially programs to provide immunity to corporates for their economic offenses. Do you agree with that?
See, to a certain extent, yes. And I'll give you my thought on this like this, that you see, cartel fines as such are not even adequate deterrent, according to me, personally, because cartels, there's huge profits. Just to give you a very bold example of a cement cartel, Competition Commission of India imposed a fine of around 6,000 crores on all the 5 companies. that was 0.5%. That was about 0.5 times. If they should have actually imposed a fine up to 3 times, what is the maximum fine, which could have been 18,000 crores. At that time, it could have had some impact. But for some reason, the Competition Commission of India, except in one case of hardcore cartel, which I luckily happened to be the prosecutor, they imposed 2 times the profit. So, A, the number of penalties are less to impose cartel to penalties. They have imposed 10% maximum, but 10% is too little according to me. They should go to the other side, 3 times the profit. Ask them to give the profits and then impose 3 times the profit. Why not? So, A, the quantum of penalties is not acting as a deterrent to the cartels.
You mean the 3 times the money disgorged?
Yes, the profits you have made from the cartel is huge. So the point is, if suppose all those unfair practices are actually discovered and prosecuted and brought to law, so then the deterrent should be sufficient. And it is not only in India. I must add here, it happens all over the world, because the fines which we have adopted, since I was a part of the Competition Commission at the formative stages, is the same elsewhere also, even in European Union, even in the US. Of course, in the US, you got a triple damages. US is an exception, because US really comes up very hard on the cartel, because it's a criminal offense there. People are sent to jail. In India, it's not. Like in European Union also, it's a civil offense. At the most, you can give a fine. But the fines the companies can pay. So anti-competitive conduct, the antitrust, the penalties are actually not deterrent, including the case of cartels. So that is why it may not immunize them. Cartels will continue, and now you got a leniency plus scheme, all the more better for them to go and rush to the commission and get a waiver. If they get, advantage of not being sued. That is the only thing which fears, according to me. The fear of getting blacklisted, the fear of getting sued for private damages, which may come to India, as I said, after the first or second case is rewarded. That is the only fear, which deters the corporates from going to the CCI. In other parts of the world, like in England, I told you, it's a rush to the commission.
Given that cartels are heinous crimes, right? Do you think there is a case for India to look at bringing them as a criminal offense? And my question is, given that the government is disposed to decriminalizing various provisions of the law, right? Will this pass muster?
In my view, it should. You see, the government ease of doing business of the Prime Minister is a very good thing. Ease of doing business is, in my personal view, is to attract foreign direct investments in India. That has already happened. That is already happening. But you should not confuse it with the deterrent, which is very much necessary. Otherwise, there would not have been raids. Kind of raid we are seeing in India, the enforcement directorate, they all kind of antique, because this government is also against corruption. We must note that also. So the ease of doing business and decriminalizing the offenses, which are petty offenses, non-disclosures, non-voluntary compliances, etc., under the Companies Act, that is fine. But cartels are very serious. They affect our economy, So antitrust is not mere compliance. It's very, very strict, because unfair business practices, unless they are stopped with a strong hand, you will keep on losing your growth. So there is a time which has come, the kind of prevalence of cartels in India. As I say, cartels are omnipresent in India. You name an association and they discuss only that. Because unless you criminalize cartels, unless you make it a criminal offense, keep on having this kind of discussion.
So, sir, my last question to you is on the draft regulations which have been exposed for public comments. If you could briefly tell us, are there any gaps which need to be bridged? What is your view on the draft regulation?
Yes. I will just give you one point. The draft regulations are good. They are implementing regulations for the purpose of the new Amendment Act, the Leniency Plus, which they have brought. They are more or less in tune with the Act, because the regulations can't go beyond the Act. It's a subordinate legislation. The Act is the main legislation. So that being the case, there is not much thing to say, because it's quite premature for us to see, because the practice will only show. But there's one thing which I would like to point out, Srinivas, that is, in practice, something happens differently, and in the law is something different. So if you apply for leniency, the law says, the existing regulation also say the same, and the new regulation also say the same. And I'll just read out that the commission shall inform marker status shall inform, and I'm reading the regulation 6.2, procedure for grant of lesser penalty. The commission shall thereupon mark the priority status of the applicant, and the designated authority shall convey the same to the applicant through post or email or fax. This is what is not happening in India in practice. For quite some time, see, I am somebody who filed the first leniency in India. That's what I'm telling you from my own experience as a practitioner. For quite some time, the commission has stopped informing the priority, the marker status to the applicant, whether you are number 1, you are number 2, or number 3. Because number 1 has 100% waiver, number 2 has 50% waiver, and number 3 and now subsequent have 30%. So it's quite important because everything is confidential. You are keeping the identity confidential. So what is the point? Why don't you disclose it? So that is the only catch which I must point out to you through this podcast, that the commission should be asked specifically what actually prompted them to stop communicating the marker status to the leniency applicant. This also is adding as a big deterrence for people to come forward. Because if we don't know, and when we lawyers ask the DG or the CCI, they say, well, you'll come to know when the order comes. What is this? You wait for the DG report to conclude, you even wait for the order to come. That takes years. So we are in a state of confusion. What was my practice status? Whether I get 100% waiver, whether I get 50% waiver, whether I get 30% waiver, I don't know. This is the only biggest problem which we as lawyers are facing. The commission does not disclose though the law says very clearly, shall convey the same through immediately. It's not happening.
The marker status
is not informed to the leniency applicant, unfortunately.
And that is critical because that decides how much of waiver you get.
Absolutely.
Net, is there a wrapping up comment from your end on the overall direction of leniency plus?
For me, it's a welcome step. It was desirable because we have in India, in industry, a series of cartels. And an investigation before the commission is for a certain period or for a particular product. It is quite possible that in the same related industry, there are cartels which are going on, which are for a different product, though in the same industry. This leniency plus will incentivize the members of those cartels to come forward and disclose to the commission. It's a welcome step, but there is a caveat. In my view, it is too little to actually expect the rush to the commission, as the commission always says. It may not happen for reasons which I have disclosed. A, there is absence of any reward. B, the whistleblowers are not included. And C, the marker status is not informed in time.
So in essence, you feel this could be a non-starter leniency plus?
No, I don't mean that. It will incentivize. It's a good program, but it is not sufficient to achieve the end with which it has been introduced. Objective. It is not bad. It's a good program, but it is not. It may not yield the results in the absence of reward, etc., and the whistleblower being implemented. And third, of course, the immunity from the private damages. It's a big thing which the parliament has to think about.
Correct. So that private damage part has nothing to do with the CCI framework. It has to be dealt independently.
It has to be done by the parliament only. They can amend the act.
And which act should they amend it?
Competition Act, of course. If the Competition Act has to be amended, you have to completely revamp the section 46 of the act relating to lesser penalty.
And in what manner should it be amended?
It should be amended to give immunity from private damages from the 53N. Okay. It should be amended to give the assurance to the leniency applicant that if it discloses and if it leads to a cartel being busted, then it will not face any reprisals either from the department or from its customers or from third parties. Because according to the existing section, even third parties can sue under 53N. It's not only your customers. It can be some imaginative lawyers can also sue you. That you call because the offences under competition law are offences in rem. They're not personal. They're against the public. They affect the economy.
Great, sir. So thank you so much for all the great perspective on both leniency plus and the draft regulation which has come from CCI on this topic.